As mentioned.
Yeah, my first question, as I said, I'm not a Muslim scholar, but my study of the Quran has led me to this conclusion that the word hudud in the Quran appears 14 times. In none of those instances is it in reference to punishment, but it is in fact used in the context of limits that Allah has set. Contoh, between relations between men and women, Allah will stipulate scan, and then Allah says, these are the hudud set by Allah, do not transgress them. So my first question is, my contention at least, the word hudud in the Quran does not refer to punishment for offenses, number one, and that in fact it is a product of Islamic jurisprudence. That is my question.
Okay, I think this is very specific. Okay, let me, my background, I think I have done some Islamic studies. I think we will have to differ in that view. I think there are various, you see, for an Islamic issue, there is a different epistemology. This epistemology is not like what we discuss, and it has to be a dialectic discourse. We have gone through the treatises, Islamic criminal law, and I think it has been a jumhur that the offenses are clear. Right? You may have a view, but most of the Muslims do not read that way. Right? So we, majority, those who are scholars, have a different view, probably from Haris. Right? But these are the views of the many who has studied that. Right? And if you want, we can go through the details through the epistemology. But I think this would have to be on a different forum. Right? So, you see, there are, this is the crux of the issues actually. We are approaching, the battle that we have right now is because we have different learning and different contexts. What Haris is saying is his view, which, in my view, is not the view held by most of the Muslims. Right? And let me get back. There is a number of issues he says. Actually, there's too many to rebut. Right? But even I'm not going to go Islamic, even secularism, we have a different view. Right? For secularism, I know Cik Omar, Cik Som, I know that our constitution will prevail, right? But what we fail to understand, even in our constitution, it recognizes Islam. And when it recognizes Islam, it recognizes all the various stakeholders and all the various jurisdictions that I have mentioned. And these are legacies prior to the constitution, and it has been carried throughout. So there is a whole host of history, legacies, and as well as practices by most of the Muslims. And this is where what I call pertembungan that we have. Right? And this clash, to me, is not healthy. It is breaking us apart. And this is the problem.
Or I think you should go with the next question. You can incorporate it into the question as well. Go ahead.
I have a different question, but I think I should have a right to actually reply to the question. Okay, first of all, what I would like to say is this, that our debate today is specifically on RUU 355. That is one. I'm not trying to run away from answering the question, but my concern is simply this. At the beginning just now, the moderator have read out my short bio. My qualification is on the civil law. I will not transgress upon an issue that is not my subject. Islamic jurisprudence is not something that could be taken for granted. Any Tom, Dick and Harry could just come to a conclusion. Just Google a certain verse or the hadith and then come to a conclusion. This is absolute arrogance. from us to say that anybody can just define this. There are a lot of scholarship involved in matters of Islamic jurisprudence. Before a scholar and ulama can come to a conclusion, they have to discuss the isnad, which is the chain of the narrative of the hadith, coming from the time of the Prophet to the time of the Sahaba, to the time of the Tabi'in, down to our time. They have to discuss on this. And then on the personality of each of those people who set the chain, whether they are credible or not. That is just one aspect of it. And then you have to discuss the context that was understood by the Sahabah during that time. And then what were the consensus of the scholars of the later years? And if there are disputes, why? So all these things we have to take into account. It is not just by reading, but by Googling something and then we find one verse from the Hadith or the Quran and then we try to argue it our way.
Okay.
I have to continue. Okay. I'm sorry, because this is very important. My learned friend, Haris Ibrahim, mentioned about Imam Shafi'i just now. Imam Shafi'i, he is a great scholar. In fact, generally, his jurisprudence is applied in Malaysia. He spent 1/3 of his wealth to study the language, the deep understanding of Arabic. 1/3 of his wealth. And 2/3 to study the hadith. And yet, he lamented that he wished he could have spent that 2/3 on the Arabic language. The importance of understanding syntax, deep grammar understanding of the Arabic before you can even have the right of say of this is right, this is wrong. I don't even understand Arabic. I'm not sure if he has the expertise in Arabic. When he doesn't. When a group of students came to see Imam Shafi'i to study hadith, what was his reply? His reply was that the thing that he fears most of students of knowledge is that if you do not have mastery, deep mastery of the Arabic language, you would fall prey to what the Prophet, peace be upon him, have cautioned. That anyone who lie about me has guaranteed a place in the hellfire. Just because you do not master the language, you cannot just argue your way out.
Aidil, the point is taken. If you could proceed to your question, please.
All right. My question is this. The case of Che Omar Cheso was referred to just now to say that the framework of our nation is secular. I disagree because it does not say that the framework of our constitution is secular, but rather our laws, secular laws. But then the learned judge also, and I would like to quote the judgment here. We thank the council for the efforts in making researches into the subject, which enabled them to put the submissions before us. We are particularly impressed in view of the fact that they are not Muslims. However, we have to set aside our personal feelings because the law in this country is still what it is today, secular law, where morality not accepted by the law is not enjoying the status of the law. So basically what it says is that morality not accepted by the law. It does not say that morality cannot be incorporated as law. In fact, we have a lot of that. Section 377 of the Penal Code is about morality. So it doesn't say that. And then perhaps that argument should be addressed at other forums or at seminars and so on. So would you agree, first, the case of Che Omar and Ben Cheso does not bar the parliament to actually pass laws on morality as well as religious law. And in fact, the learned judge actually expressly said that it should be brought at other forums, including the parliament.
Okay.
Note, you said you do not agree with the decision. There are many decisions of the federal court that I too don't agree with. But guess what? As long as it remains untrammeled, it is still good law. That's the position. That's how it is in this country. And I think that's how most countries see how that works. Now, morality, whether it's the morality of the Muslims or the Christians or the Buddhists, there is no hindrance to legislating to make it law. There's no impediment. There's no bar. So long as it does not offend the precepts of the Constitution, for instance, Part 2, which pertains to human rights, if it does not offend, no reason why morality cannot be legislated upon.
The Allah case in the Court of Appeal, and you said Article 3 says the state must promote, protect and defend Islam. I don't think anyone has a quarrel with that. My question to you is, how does RUU 155 promote, protect and defend, 355, promote, protect and defend Islam?
The case of Kalimah Allah expressly says that it is the duty of the power that be to promote and to assist the people to actually have their life in accordance to the injunction of Islam. So what RUU 355 actually does is that it provides a enhanced jurisdiction for the court to have better powers to decide their cases. But I would like to put this very clearly. What it does is not that it does not straight away say that for this offense it is 30 years, for this offense it is 100 years, 100 lashes and so on and so forth. Why it does not? Because it is not the power, it is not the business of parliament to be discussing or debating about issues on Islam. Matters of Islamic law is within the state power. So what the parliament does is simply providing further power to the respective state legislative to actually discuss and debate the need, whether or not there is a need for them to increase the, first of all, to increase the punishment, and also whether to create further offenses. That is all. It gives the democratic right to the various state legislative assemblies to debate whether there is a need. If we say that the parliament should not do this, then we are saying that the Dewan Undangan Negeri does not have this right. They do not have the right, and their right is only limited to this 3 years imprisonment, 5,000 ringgit fine, and 6 strokes of whipping. By having this, then the state legislative can debate the need of further, whether there is a need to increase and so on. So this is how it actually promotes Islam, as declared by the Court of Appeal in the case of Kalimah Allah. This question is addressed to either of you. Act 355 of the Sharia Court Criminal Jurisdiction Act is an act of parliament to confer the necessary jurisdiction to the respective state legislative assembly or Dewan Undangan Negeri to enact the necessary law in respect of Islam and the Sharia. It does not in itself introduce any Sharia offense or prescribe any Sharia punishment, but simply is an act of parliament based on the federal constitution to provide for an outline of what the state legislative assemblies may or may not enact and pass. In other words, it merely provides for the shielding jurisdiction. By opposing the amendment to Act 355 to confer an increased jurisdiction, Parliament is actually shutting the doors for the respective Dewan Undangan Negeri to actually have their own say as to what the states should or should not be able to prescribe on matters relating to Islam. My question, therefore, is this. Why are you opposing to allow the states to have their democratic rights to debate, pass and enact laws on matters of Islam with an increased jurisdiction?
What I said about Act 355 is, all it does is talk about punishment. All right? It doesn't relate it to any offense. At the end of the day, the federal law can only give jurisdiction to the Sharia court to act in accordance with the federal constitution. This Act 355, I mean, earlier it didn't really matter because the punishment was so low. But now when you're increasing it to this level, there must be clarity. We must know what offenses you're talking about. You say it doesn't include hudud, but I've shown that actually it does include some of the hudud offenses. So what is it? What is going on? What is it that you are talking about? What offenses specifically are you talking about? You can't say you leave that to each state, which means it can differ in each state. If it differs in each state, where is the parity? That means, actually to me, you could even be infringing Article 8 because it'll be different in every single state. So that's what I'm saying. That's the problem. I'm not saying don't have an act to deal with this issue. Please don't get me wrong. I'm saying do it in accordance with the Constitution. and do it with clarity so that people know whether they are committing a criminal offense or not, or whether they're committing an offense or not. Right now, they don't know anything. So I don't think we're taking away any powers from the state. The federal law is required to empower the state, Sharia, but it must be done in accordance with the Constitution.
Offences that do not come within the genus precepts of Islam. Now, that is firstly in itself troubling. In a news report today, referring to the suggestion by the Pasir Putih MP, I think this was in the media yesterday or the day before, that unwed mothers, women who have conceived out of wedlock, should also be whipped. He now extended it today to say, look, we might as well also whip the drug addicts. And this is what he says, his reason. Now, the reason to me is the one that's troubling. Put fear into them to stop taking drugs. Now, let's make this comparison. The drug offences comes under our federal laws, which means these are laws for the common good of all people. All right? But here you have a situation where you're talking about increasing. My question, increasing it from 3 years to 30 years. Are you trying to coerce people into adhering to the tenets? Because the fact that you are trying to put people in fear of men and not of God in itself is a violation of a precept of Islam. Because Allah says, do not fear them, fear me. But here, these laws are being proposed in order to put the fear of men in men. It's here. Put them in fear. So for that reason, I think the question of it going to the state legislature to debate these issues, for me, yes, I certainly wouldn't want to allow that to happen at all.
Simple one to Aidil, actually. Do you believe in the supremacy of the federal constitution?
Yes, definitely. I agree with the supremacy of the federal constitution. But the problem that we are having today is that based on one single document, we are quarreling over what it means. And why is this? How many minutes do I have?
It's okay, go ahead.
And why is this? I would argue why we are having this problem, that on the one hand, that side of the table is saying that the federal constitution is supreme. This side of the table is also saying the same thing, but we differ in how the interpretations of things are being done. Why is this? So I would argue it is because the problem is that, and I would like to quote a judgment, if I may just be given a bit of time.
Very quickly.
Yeah, very quickly. Yeah. In the case of, in the Indira Gandhi's case, this is a famous case actually. Indira Gandhi's case is a case where it is a judicial review over a conversion certificate for the child. In that case, the majority decision of the federal court, of the Court of Appeal, actually dismissed the appeal. But what I want to refer to is the minority judgment of Justice Hamid Sultan. Justice Hamid Sultan is in his judgment, which I think is a remarkable judgment, despite the fact that he was actually favoring the civil court, not the Sharia court. But he gave a very important judgment in which he said, the lawyers and judges as well in Malaysia is actually having a problem grasping and understanding our federal constitution. Why? Because when we gain our independence from British, the British failed to actually instruct us on how is it about that we need to go on the issue of the supremacy of the federal constitution. Because the UK, the British, they do not have a written constitution. And in UK, it is the parliament that is supreme, not the federal constitution. So because of that, we are having a mess of how are we going about on the jurisprudence of the supremacy of the federal constitution. And this problem is compounded by the fact that we have a lot of lawyers coming back from the UK, and then they, for the first time, they open up the federal constitution and they just interpret it at their whims. And now, currently, students who studied law in UK, they come back in Malaysia, they take their CLP. There is not even a subject for constitutional law. So that is the problem.
20 seconds, Aidil.
All right. So this is the problem. And then they came back. They don't even have a proper understanding of the national language. When they argue in court, they cannot appreciate the national language. So how can so they bring in the ideas of morality that is foreign from our concept of akhlaq. Because if you appreciate the national language akhlaq, which has the root word from yakhluqu, makhluk, the fact that we are created, we are creature. So we would not be arguing on the federal constitution on morality based on foreign concepts, but from our own tradition. So that is the problem. I do believe that federal constitution is supreme, but it needs to be interpreted based on our own tradition.
Okay.
Many things to rebut, but I think I want to illustrate on this issue in relation to a different interpretation. We are still saying we believe federal constitution is supreme. But I greatly disagree with how the Datuk Ambiga and Haris interpret the constitution. You see, all right. Okay, can I be given?
Please respect the speaker.
All right. Now, you must understand, as I mentioned just now, our Article 355 is not a substantive law. We have a precedent for numbers of years which stipulates that the limits of sentences of Sharia courts. And this cannot be unconstitutional, right? It has been there for decades and decades, and no one has argued that as unconstitutional, right? The law does not require for the parliament to prescribe. Why? Because the federal constitution states that it as may be conferred by the federal law. And because of that, you cannot argue it's unconstitutional. I cannot understand this argument. Why it is unconstitutional, right? Now, it is very important. The problem is this. You must realize, I must say this, the Muslims are governed by a different code of conduct, which they wanted to since the Merdeka. It's part of a constitutional compromise. We want that. Most of the Muslims want that. Notwithstanding, there may be some people who disagree. The fact that it has to be passed by the state legislature indicates that it's passed democratically by the people. Right? It is passed by the majority of the people. And that reflects how they want to be governed. We can argue as much as we can, but no one can deny it's a law passed by democratic process. It is a law viewed by most of the Muslims as applicable to them. And this is founded in our constitutional compromise. Our constitutional, our constitution provides for that jurisdiction. Our constitution provides the stakeholders for this. And these are legacies we are continuing. Now, when we interpret against what has gone in the past, that is where we are now. We are going head on too many times, right? We don't have to do this, ladies and gentlemen. And because we cannot be doing this all the time. It will only fracture our society. Now, this is my view. That is why I greatly disagree with how the opposition, Datuk Ambiga and Haris is interpreting the constitution. And I believe there are precedents from decades and decades, and I think case laws to support this. With that, thank you.
Thank you.